Don't you just don't want to go, well, what's that mean?
Yeah.
Would everybody please stand for the pledge of allegiance? I
pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Okay, we have everybody we absolutely need. Oh, Phil is won't be with us and has asked not to be included in this hearing. But the hearing we're having this morning, public hearing, is to discuss and receive any information that the board needs to make the final decision on the Edgar County Commercial Solar Energy Facility Ordinance.
Okay. I'll pick up from there. So I think I know we've circulated a draft ordinance to everybody some time ago. There was some discussion that we had during a study session regarding that. We made some adjustments to it, and then we published it for hearing. So in other words, before you adopt an ordinance like this, you have to do a publication in the newspaper. And that publication that allows people from the public to come and say, hey, this is what we think, or people who might be looking at projects. But anybody then has an opportunity to be heard about what, hey, this is what we would like to see, or this is what we would suggest, or any concerns people may have. So that's what we have. So then we have a public hearing on that issue, and that's what our purpose is for today. I am going to go, I'm going to try and hit the highlights of it. It's rather than get too far in the weeds, because we've already as a group gone through the ordinance before it got published for the public notice. So it'd probably be time best used with me answering questions, and then if people have anything they want to say from the public, they can add any information. So with that being said, I think as most people know, the state passed a citing statute in 2023. Like it or hate it, I can tell you which way I fall in that, but irrelevant to what I'm going to tell you is the state passed a citing statute in 2023, which essentially mandates counties to adopt certain rules if they want to regulate wind or solar projects within the county's borders. The citing statute essentially set out parameters as to what they wanted, things such as setbacks, what the sound limitations could be, how you evaluate IDNR, things like that, wildlife issues. All of those things are things that are mandated from the state's statute, which was different than how we operated before. Now, one good thing about that state statute, if there is one good thing from the state statute is it allowed the counties that are unzoned, like Edgar County, to regulate it through an ordinance. Before, it was arguably you wouldn't have any authority to do that. So what we did is we prepared up an ordinance. The one you had in place or had started with actually wasn't too far off of what we would have suggested. So back in 2023 when this all came out, we worked with the Association of County Board Members and the Farm Bureau to come up with a sample ordinance that people could utilize. And so your ordinance looks pretty close to that anyway. So we did some adjustments to it, then provided that to you. And the purpose or the reason for the public hearing and having to change your ordinances a little bit is just to make sure that we're compliant with the whole state statutory scheme. Plus, there are some projects that apparently are looking at doing development within the county, so we want to make sure that the county ordinance is ready for that, number one, and it's compliant with any statutory requirement that the state is mandating. I'm going to go through some of the highlights of it, just so that it's out there and everybody has it. One is under this ordinance, you would have essentially the setbacks come down to exactly what the state mandates that you do. You don't have authority under the state statute to expand those setbacks. There's nothing we or I can really do about that. It used to be we would see a lot of variance in terms of how setbacks look. Sometimes it's 500 feet, sometimes it's 1,000 feet, sometimes it's 20 feet. But The way it's laid out is occupied community buildings and those that are non-participating residences have to be 150 feet, or the development has to be 150 feet from the foundation of those buildings. That's the primary one. You also have 50 feet from the nearest edge of any public right-of-way and 50 feet to the nearest point of a property line of a non-participating property. So it's 50 feet to the property line if somebody is a non-participating property, it's 150 feet to the foundation of the house. If you have multiple parcels involved with a project, the state doesn't allow us to have setbacks from those participating parcels. So if you're going from one parcel to the other, it allows them to go straight across those properties without any boundary. The rest of the ordinance looks relatively akin to what most other counties have adopted in that regard. So a couple big things that always come out in these projects relate to road use agreements and decommissioning agreements, which is probably where the biggest issues lie right now in terms of projects. So before a project were to come and get a building permit, so your ordinance is laid out, let me back up. Your ordinance is laid out in two different ways, or two different stages. One is, whenever a developer comes, they would have to get a special use permit from the county. And that means they would have to come, they would have to go through a public hearing. County board or some committee of the county board would have to sit and hear that because you're not formally zoned, you don't have a zoning board. So somebody either from the county or the county committee would have to hear that project. If then the county, they then would make a recommendation to the county board, the full county board. And then if the county board approves it and approves a special use, it then goes to what we would call a building permit stage. So first stage is they have to get a special use permit, and then they would have to come back and get a building permit. And sometimes between those periods of time, between the special use and the building permit, it might be a year or more. Sometimes it's 6 months. On large projects, you tend to see a little bit longer because there's a lot of that the developer has to do on their end in terms of financing, investors, getting road use agreements nailed down, and decommissioning agreements. Which brings me to the whole decommissioning agreement and road use agreement. So those two items would be required before they could get a building permit. There's a whole host of items they would have to get before they get a building permit. One would be, they would have to provide, for example, a landscape plan to the county would be one example. They would have to provide their survey engineering drawings to show they're compliant with everything, the setbacks, for example. But also the two big agreements that would have to be worked out before they get a building permit are a road use agreement and a decommissioning agreement. Those two items by themselves typically take quite a while to negotiate. But the important thing to keep in mind is both of those items would come back to the county board for approval. So those two big ticket items, so when you see it from a county board's perspective, you would first see a special use permit application filed, there'd be a public hearing, you would make a decision on that special use. If it's approved, you then would see a road use agreement come before the county board for approval, and a decommissioning agreement then come before the county board for approval. That's all before they could ever get a building permit. So those two items are the two big ticket items after the special use. In your ordinance right now, in terms of...
I got a question.
Yes, sir.
Also, the ag
Mitigation.
thing, they have to have that before they come to the building permit.
They would have to have that before the hearing on the special use.
Before, okay.
Yeah, and that's by statute. So the
All right.
state statute mandates that they have the AMA fully
Right.
executed by the time the public hearing takes place.
The first one.
The first one,
Okay.
special use hearing.
I wasn't sure on that.
Yeah.
I've read through that, but I wasn't sure where it was in the process.
Yeah, no, it comes at, they have to have it for the public hearing.
Okay.
Used to be, we would mandate that they have that before they even file their application.
Mhm.
But then, for reasons I cannot explain, they decided that the state in their statute said they only have to have it at the time of the public hearing.
Okay.
Which is fine. If they don't have it, they're gonna be out of luck. So most developers have it before they get to public hearing. In terms of your fees, A couple things that we had talked about when we did our study session is we talked about fees. I believe with your application fee, there's two fees really that come into play: a special use application fee and then a building permit fee. The way yours is laid out right now, if a project comes in for the special use special use permit fee, it would be $20,000 for the first 4 megawatts. So if a project comes in, and I'll preface this that there's kind of two worlds when it comes to solar. There's community scale solar, and then there's utility scale solar. Community projects are those that are 5 megawatts and under. If you're over 5 megawatts, it's a utility scale project. Within that community scale world, you will sometimes see projects that are 1.5 megawatts. This is kind of the small end, up to 5 megawatts. A 1.5 megawatt project is going to take up about 15 acres-ish. A 5 megawatt project is probably going to take up about 30 to 40 acres. So a project coming in, regardless of the size, if they're community scale solar, they're going to have to pay $20,000 for that, for their special use permit fee. That means that's cost to cover whatever costs that you would have as a county in terms of hiring engineers, hiring an attorney, whether you need to have a hearing moderator, just things like that, that's what that would cover. If it's above 4 megawatts, they have to pay $5,000 per megawatt for every megawatt that's over. So if somebody comes in with a 10 megawatt project, they would have $30,000 plus the 20, so you'd have a $50,000 building permit fee. So that's how that would look. If you have a utility scale project, one that's 100 megawatts, you'd have the $20,000 fee plus $5,000 for the 96 megawatts beyond that. Now your fee's capped. Your special use permit fee is capped at $250,000. If they go over that amount in a hearing, which is feasible but very unusual to get over that amount on a solar project, they would still have to reimburse the county for any costs above that amount. So then whatever is unused from that special use permit fee is refundable back to the developer. So if the county goes through a special use permit fee, say they get $250,000 and only spend $150,000, you would refund back $100,000 back to the developer. That's the easiest way. One of the requirements within the statutory scheme is we have to have a reasonable fee. That's the easiest way to make it reasonable, is to make the special use permit fee refundable. Okay. Any questions on that fee structure?
On the building permit fees, what is that used for?
So building permit fee, right now your building permit fee doesn't have an initial dollar amount, like a $20,000 per 4 megawatt. It's just $5,000 for every megawatt of a project.
Right.
And we had talked last time that you wanted to set a maximum fee of $100,000. Typically, the fees related to building permit relate to review of the building permit materials that come in. So when they come in and ask for a building permit, they're going to have to provide a lot of documents in relation to that. So a lot of it's engineering documents, some of it's road use and decommissioning agreements that you guys have already seen. But then, you might see landscape plans or grading requirements, dust mitigation plans, things like that. So all of that essentially then gets reviewed mostly by either an engineer or an attorney, sometimes both on really large projects, to just go through and make sure everything that is required of that building permit is there. Now, building permits aren't discretionary, so if they've checked the box and everything's been provided, you have to provide that building permit. The fee itself is used to cover whatever those costs might be for the county, so hiring an outside counsel or having an outside engineer look at it. They would, those costs would cover that. In addition, to the extent that there's administrative costs after a project has been built or in the construction process, so you might have You know, we've had situations where we've had to send enforcement letters saying, hey, we're gonna pull your building permit unless you get compliant with the road use agreement. Or, hey, you're out of compliance on this particular issue, you need to get compliance, you got 60 days to do it. So it paid those kind of costs too, that you might have like during the construction phase. You might also see the same kind of thing during the operation phase. Every once in a while, a solar developer gets out of compliance with something. Sometimes it's weed management is a big issue. So if they aren't compliant with keeping the project weed-free, especially noxious weeds, you might have some enforcement action to tell them, hey, you need to get compliant. We're gonna give you 60 days to eradicate the weeds. If you don't have it, we're gonna take some action on it. So that's the kind of thing it would go, those kind of costs would go towards. Your ordinance right now, we talked last time about this issue. Right now, oops, excuse me. Right now, you'll see on page 15, there's a set of hearing factors. In the land use zoning world, we would call those the LaSalle-Sinclair factors. That's just a reference to two Supreme Court cases. So called LaSalle, and the other one's the Sinclair oil case. So we all call those LaSalle-Sinclair factors, listed on page 15. We talked last time, there was some discussion about whether to keep those in or take those out. The only thing I'll tell you, it's entirely up to you how you want that, whether you want those to be included in the ordinance or not. What I will tell you is, there is some gray about whether or not, under the current statutory scheme, whether the county can still apply those LaSalle-Sinclair factors. I generally recommend the counties to just leave them in. However, some counties say, we just want to make it black and white, and you would take out those LaSalle-Sinclair factors. If you do that, the only caution I have about it is, then your ordinance becomes essentially a check the box kind of situation. If a developer comes in and they meet all the requirements that are listed in the ordinance, then they've met the requirements. The LaSalle-Sinclair factors are very much factors to be weighed. And those factors, the primary one is, is the project detrimental to the health, safety, and welfare of the community? That's one of the factors. Now you can imagine there's a lot of subjectivity to that issue in some ways. So just keep in mind, if you want to leave them in, you're totally free to leave them in. If you want to take them out, totally free to take them out. But if you don't have them in there, your ordinance will become essentially, is the item there or not there? And that's essentially what that ordinance would become at that point.
So if we take them out, I'm not thinking of a specific example. If we take them out and something occurs that is a detriment to the health and safety of our population, we wouldn't have any grounds to pursue that?
Well, you could, it just wouldn't be at the special use stage. So the hearing factors only come into play in the special use permitting stage. It only comes as to whether or not you're going to grant the special use or not grant the special use. It doesn't come into play, let's say there becomes an issue where the panels have been, the panels have been damaged, maybe there's a wind event or tornado and they've scattered onto a neighbor's property. You can still go in and force them to remove whatever panels have been damaged and et cetera. You can still do that. Like, that's not necessarily an issue. It only comes into play as to whether or not you're going to initially grant the special use or not grant the special use. That's it. It doesn't come into play after, it doesn't come in during construction, it doesn't come in during, one example might be, this is not a great example because it gets into a whole lot of permutations. But let's say the property where it's being proposed has been subject to mine subsidence through the years in a significant way, and it's still happening. Let's say the mine just closed, there's a mine shaft under there, the mine shaft isn't very deep, and there's been, it closed 5 years ago. A lot of people say you still could get mine subsidence for another 10 years, for example. So if that's still going on, that mine subsidence might still be an issue. That's not covered in the state statute. There isn't a specific reference in your ordinance about that because it's hard to game plan for every possible scenario. But that might be a health, safety, welfare issue where you say, hey, wait a minute, like we get it. We are compliant with the setbacks and all the sound and all those issues, but what about this whole mine issue? And so that might be an example where you might say, hey, we're not gonna approve that project where it is because of a particular safety issue. Now, most developers probably aren't gonna build in that kind of scenario anyway, because they recognize a risk. Old mine shafts aren't really that as big of a risk as newly abandoned ones, but it could happen. So that's an example. It's a very extreme example, probably. But that's an example of one where you may say, well, we're not going to grant that special use in that particular circumstance. But those factors only come into play in the special use permitting. Yes, sir.
Do solar farms have to be built close to power lines so that the energy produced by the panels can be hooked into the power line? There's a rumor about the one that's supposed to be put in east of town. Farmers are not allowed to cross their land to get to the power line. Is that true?
Yeah, so generally, they have to be able to hook onto the power line
Okay.
to put power onto the grid.
Okay.
There is a interconnection agreement. They have to, especially when you get larger scale ones, they have to do an interconnection agreement.
Okay. I heard that rumor, I just wondered.
Yeah.
So.
Yeah, they have to be hooked into the grid. They may, if a project's large enough, like a large utility scale project, what sometimes you see is they'll build a substation and transmission lines to the substation.
Like over around Kansas,
Yeah.
that runs in the substation.
Yeah.
The solar farm over there.
I'm not familiar with it specifically, but that probably is the
The
case.
substation's right across the road from the solar farm. So.
Yeah. Yeah, we just had, like, for one example is we just had one down in far southern Illinois where, I want to say it was a 3,700 acre project, and they built the project, but they had to run 7 miles of transmission line to an old fossil fuel plant. And so they had to build a substation plus what they call T-line or transmission line to run to the,
What's the procedure when the life of the panels are done? I know they gotta remove them, but what do they do with them? They haul them back somewhere, recycle, or do you have any idea what they do with all those panels?
yeah, that's a good question. So, we talked earlier about the decommissioning agreement that we would make them force them into before they get a building permit. What often, one of the issues that you see come up is what happens to the panels after the life. So most developers try and take a stance of like, well, hey, by the time this comes around, there'll be recycling facilities nearby.
Yeah.
Right now, there aren't any.
That's what
nearby.
I wondered.
There are
I
some,
didn't
but
see
not
any-
nearby.
I didn't see anything in here about
Yep.
the procedure. It says it has to be decommissioned, but it didn't say what procedure do you go through to get rid of the panels. You'd think they have that all written out.
They would, so they have to have a decommissioning plan
Okay.
when they come. Now, oftentimes, when I mentioned we go back and forth with them on road use and decommissioning, sometimes for 6 months,
Yeah.
arguing about it.
Understand that, yeah.
One of the issues always comes up is the developer lowballs the cost of trucking the panels because they presume there's gonna be some facility to take the panels in 30 years.
I see.
Our position is, well, we're concerned about 30 years from now, but
Should be.
what happens if 5 years from now, the project has to be decommissioned? Our position always is, you have to estimate what the costs are gonna be to truck that if you're planning to recycle it. I think the nearest recycling facility is in Ohio, right now. So we always say, go put in your plan what the trucking cost is to take it to Ohio. Which they're always hesitant to do if they're not gonna use a landfill. The other thing you run into is they'll
Well, it could
say,
go to landfill anyway, I would think, so.
yeah, they sometimes will say, we're just gonna truck it to the local landfill. The problem with that is, the local landfill often doesn't take it, because A, it's either too much,
Right.
if you're talking, 40,000 glass panels, the landfill's gonna say, hey, you're not bringing that here. And, so you're gonna have to find a different facility, and so sometimes it may have to be a hazardous waste facility. And so we oftentimes, when I say it takes some time to negotiate those things, our engineer will look at it and go, hey, what about X, Y, Z? And we're sitting there and we're saying, hey, you can't truck it to the local landfill. You gotta find a different location that you can take it to. So when it comes down to it, the decommissioning agreement and the decommissioning plan all try and take that into account. There's a lot of negotiation where we turn screws on them about that issue. Typically, the decommissioning agreement will be subject to the county's review periodically, so it may be every 5 years. Some counties are comfortable saying, hey, we'll let you renegotiate or look at this issue again in 10 years. I usually say, one of two things will be worked into the decommissioning agreement. Either A, you're gonna renegotiate it every 5 years, or B, it's gonna have an inflation escalator to the amount. And the way the decommissioning works is when they come in and build the project, they then have to post either a bond or some other financial assurance, like a letter of credit, to the county's benefit. So that for some reason, the developer walks away from the project, you, the county, have funds that you can, or the landowner, can call upon to then remove the project out of commission. So it's not just some abandoned
I
soil
just wanted
fields.
to proceed.
So, we've hired you, the county has hired you to represent us in this. So like the decommissioning plan and all the others, they will work with you, with us, you're as our representative to make sure they're in compliance with everything that
Yeah.
needs to be done.
Yeah, so if a project gets approved and you end up in this phase before they're gonna come back for their building permit, we'll negotiate that decommissioning agreement. Some counties have a standard one, and on the smaller ones, we could probably use some of the standard form we have for that. The larger ones, especially with battery storage, it gets to be a little bit more of a drawn-out process. But to answer your question, yes.
Well, I just noticed, there isn't a whole lot in here about
That's what I was
decommissioning.
wondering too.
And that was my concern, and then, of course, I've read some of the statutes saying, the mitigation thing, and a lot of that's not in here is, they have to be in compliance with those two different things. So, there is standards set up for them to have to follow
Yeah.
on all this.
Carl, we'd have to have adequate representation
Right.
and then an engineer.
Right.
Either that you recommended or the attorney that represents us or that we get.
Yeah,
Right.
yeah.
So we'd have to have two groups helping us.
Right.
Right.
Yeah, and then when it comes to decommissioning, one thing oh my God, the bird's got something to say about the decommissioning.
He's decommissioned.
He might be, the, one thing that will, one thing is, the state statute gave us some handcuffs in terms of, it essentially says, a developer has to follow the terms of the AIMA, the Ag Impact Mitigation Agreement, when it comes to decommissioning. One of the quirks in the Ag Impact Mitigation Agreement is there is a line, subparagraph A on, I think, this first page, states that the county can have additional requirements.
Yes, right.
So there's all this great, okay, well, state statute says you have to follow the AIMA, meanwhile the AIMA says the county can have additional requirements. So we oftentimes have a lot of back and forth. The way we view it is the AIMA is the baseline. You have to, at least that's the floor of what you have to do. We, the county, you may have additional requirements. The real big issue comes into play of when is the financial assurance going to be posted and what's the amount? Because the way the statute is written is that they have to follow the financial requirements in the AIMA. The AIMA, unfortunately, lays out that they have to post 10% of the cost of decommissioning through year 5, then it bumps up to 50%, then after year 10 it goes to 100. Our viewpoint is that is shifting the risk to the county unfairly. And most developers, I'm not gonna say all, most developers essentially go, okay, we'll post 100% from year 1. Now, there's all sorts of horse trading in that, it comes down to that.
So
but
we can do that, in your
feasibly,
opinion?
yeah.
Okay,
Feasibly.
because I keep hearing that from people in the public, what's gonna happen when it's all over, and who's gonna foot the bill if they walk away and all that. So that's a big issue as far as I'm concerned.
Yeah, and there's, what I'll say is because of the way the statute was written and passed in kind of a very hasty fashion, it left a lot of gray. And one of the grays is how much authority do we have when it comes to decommissioning and those financial assurances? Most developers are willing to post more than what the AMA financial requirement is. There's a lot that goes into sort of that back and forth with them to get that, but typically we have some success getting that. Can't guarantee it, but usually there's some success.
On the issues on 15, I know that if we got done with this hearing and we have not discussed the issue, it can't be changed before we approve. So do we need to, what do we need to do to, I guess, guarantee us options, or do we need to say we want those items in right now?
Do you mean the factors that we talked
Yeah,
about?
the factors.
I think we've discussed it, so I think you have the option, and it's in the draft ordinance.
Right,
So-
so I get the feeling everybody's comfortable with those remaining in.
I think so. The more that we can do to help protect,
Right.
you know, the
Right.
community, the
So,
more
I
we
think
should
we
do.
need to let the hearing know where we,
Right.
so those that are interested out there know the direction that the board is considering.
If I were to make a recommendation, I would leave them in.
Right.
But I'm not, I don't vote for you, so it's up to
Well,
you.
at this point, is there anybody that objects to the factors at this point? Okay, well then we're.
It's easier to take them out later than
Right,
try to, yeah.
Yeah, and the main thing about the factors, you can't apply them in derogation of the ordinance or statutory requirements. So you couldn't say, if an applicant comes in and meets all the setback requirements, for example, you couldn't say, yeah, you meet the setback requirements, but we'd like them to be farther back, so therefore we're going to deny it. Like, that's an example. You just have to be careful how you utilize those factors, and we're very cautious about that issue.
well then we'll have legal representation to caution us or
Yeah.
guide us through what we need to do. Does anybody, I don't know who I'm looking at here, recognize, is there anybody that would like to speak to that issue that's currently sitting in the audience?
What I would suggest, Chairman, is I'm almost done.
Okay.
And what I would suggest is once I'm done, anybody from the audience could ask me questions, then provide any information or testimony they want to provide, and I'm almost done.
All right,
Okay.
because we're,
You gave the lawyer a platform, and now I'm starting, but
the clock is running.
yeah.
We're familiar with that.
One thing to keep in mind is this governs any solar project that would come in. It also would govern any solar project that has a battery storage that's part of it. Battery storage, if somebody comes in with a battery storage facility that's separate, you would want to have a separate ordinance for that. Same with wind. You have a wind, you would have a separate wind ordinance. There is some legislation that was proposed very late in the state's legislative session last month that would have provided some very significant changes when it comes to battery storage. One of those changes is that right now it's not regulated by the state.
Standalone batteries.
Standalone battery storage is not. If it's part of a solar facility, by the state statute, you govern it within your solar ordinance. But if you're talking about standalone battery facilities, the proposed legislation would have prohibited an unzoned county from regulating battery storage in the county, okay? Now, ultimately that did not pass because they were spending so much time on the budget that they didn't get to until, they didn't pass the budget until 5 minutes or so to spare. So they never even voted on that issue. Those proposals are likely to end up in the fall veto session. So I'm just making you aware of that. If anybody has any questions that I can help answer beyond what we've had, feel free, and I'm happy to answer them, whether it's from the county board or from people in the audience. I can help try and answer those questions, whether it's about the ordinance or state legislative issues.
Did you say that the legislation was to allow or not, the new legislation was creating a pathway that the county could not regulate?
Correct, so,
Okay,
yes.
just making sure I understood which way that was going.
Yeah, so
Pretty
the-
sure, but,
The basics of it is, it would work very similar to how the state has decided to regulate wind and solar. The key difference though is with wind and solar, the state gave power to unzoned counties like Edgar County to regulate wind and solar within their borders. With battery storage, the proposed legislation would be only a zoned county could regulate them within their borders. An unzoned county like Egler would not have that authority. So, it's a very different approach. So, with that, does anybody else have any questions?
I think, I have had some feedback from one of the proposed companies that would like to put solar in. And they were questioning the issuance as onerous to 1.5 miles, letting all participants and non-participants notified by mail. Is that correct?
On the BES ordinance.
Right. Oh, it's not included in the wind?
No.
I think there might be a provision in there about a before they apply, they have to have essentially a town hall, making
Right.
sure that everybody knows that this is going on, because a
They
lot
have
of
to
times.
notify every landowner and
Yeah.
resident
But-
in that 1.5 miles.
Right.
Yes. So what's the concern, I guess?
I don't know.
What
Do
I
we
would-
have any representatives?
Yeah, I think their council's here, and they had, we had talked some about the ordinance over the weekend. What I would suggest is just let them address it, and you can, because I don't want to butcher it.
Okay, that's fine. I just want to make sure.
Yeah,
it came
but
out.
another thing I wanted to point out to the board, there's two companies in here that are somewhat pretty serious about this, have ground lease. But, your question about the substations, they're going into Indiana on both projects with as of right now, that their plan is go into Indiana, put the substation, and then, of course, the 2 power lines over there are in Indiana.
But they have to cross some other farmers' land to get to them.
That's
Well,
their problem.
yeah.
That's their problem.
Right, but yeah, and they have to have, lease agreements with them.
I'm guessing that if they can't cross lines
And
and
they
they
can't have
can't
the
get
solar
it,
farm.
then they wouldn't invest the
Right.
money.
Right.
Okay?
But if this these 2 projects do go into Indiana,
Yeah.
Right.
and obviously we can't control
No.
what happens over in Indiana.
Yeah. What we're talking about is on page 4, at the top of page C.
Now, we can let them talk to us about it. So,
Yeah. But I would suggest if nobody else has any questions for me, we just let whoever from the public who has comment to go ahead and.
Okay. Andy, do you want those to be sworn? I wasn't sure. I know you weren't.
I'm not sure we have somebody swear anybody in.
Okay. Well, I wasn't sure if you were on behalf, or if the chairman was on behalf of the county. So.
It's recorded, but.
Right. So I just,
Yeah.
Okay, well, if it's okay, I'll go first. My name, Seth Upoff, and I'm here with Hypa Solar, and wanted to discuss just a few things about the proposed ordinance. So Andy had indicated that he and I had some discussions about this. We had gone through the proposed ordinance. We've been here at several meetings before. Both I've been here, and Andy Byers and other representatives of the company. And so we just wanted to provide a few thoughts from our position as a developer, because everybody looks at this from a little bit different perspective. So if it's okay, I'll just go sort of in order as we've marked them out in the ordinance, and I'll try to give you some page references. So the first section that we wanted to bring to your attention and provide some thoughts on is at the top of page 4, paragraph C, which is what you were just mentioning. This is sort of the open house provision, which my understanding is typically when counties put this in, you're wanting to make sure that the residents in the area are fully aware that there's a proposed project that's coming to the area. And so don't have a dispute with the intention behind that. We're looking at a couple of things in relation to the timing of it. So the way you have it written is at least 60 days prior to the filing of a special use permit application with the county that you have to hold this, I'm just gonna call it an open house. One thing that we thought you might wanna consider is making that, if you're gonna have the 60 days, have it be 60 days prior to the hearing date. Now, it's a little uncertain when the hearing date would be, but typically, once an application is filed, there's a period of time where the county reviews the application and determines whether or not the application is sufficient, that it meets all of the necessary requirements just to move forward. Not saying that it's approved, but that it's complete. And then the county has 60 days to hold a hearing within that time. So once the hearing date gets set, you can then say, okay, you gotta have this have occurred 60 days prior to that hearing. Now, you don't know when the hearing is gonna be set, so what the developers would have to do is, before they file their application, they'd have to make a best guess and hold this prospect of this open house. The one thing about having it prior to you even filing the application is that, you know, that's also a little bit uncertain for the developers. They don't know when they're gonna file it, so they're trying to determine it. But the first request was just consider making it 60 days, or if you want to shorten it to 30 days, prior to having the SUP hearing. Because the other part of it is too, is somebody could have it way out in advance. You know, you could have a hearing, you know, or an open house now, and then you could file your application a lot longer down the road, and people may not realize it's the same project that's being discussed and all that. So if you made it tied to when the SUP hearing was going to occur, it might make it a little more in time for the people in the area. The other part of it was reducing the distance of notification from 1.5 miles to 0.5 mile. When you are talking about these types of projects, typically the major concern of people around the area is the visual impact. And with these type of projects, with the way the height typically is, when you start to get out to 1/4 mile, they start to blend with the horizon. When you get out to 1/2 mile, they're really blending in with the horizon. I think once you get beyond 1/2 mile, it's hard for anybody to even visualize them or see them at that distance, given the topography that we have here in central and southern Illinois. So when you start going out 1.5 miles, there's a lot of people that are gonna get caught up in that ring that aren't gonna be impacted by the project. Additionally, since you border on Indiana, you also create this scenario where now we're sending a bunch of notices to people in Indiana who still have the right to come here to your hearings. They're open to the public, and it's not just the public from Illinois. But those aren't any of your constituents, you know. Not that you couldn't hear their concerns, but it just creates a different dynamic when you're sending a bunch of notices into another state and letting them know about a project over here. So that can still happen with the 1/2 mile, but again, it just reduces the number of those notices that have to go out and the number of people that, you know, likely aren't even gonna be impacted by the project, you know, getting these notices in the mail and then starting to wonder what's going on. So those would be a couple of requests on that topic. And I don't know if you want me to just keep moving forward, Andy, or if you wanna.
Unless
Yes.
they want
Okay.
you to, I'd say.
The next is down further on that same page, on page 4. This would be under the special use permit application, sections or subsection B2. Talks about 2 legal descriptions being submitted. The first being just the general properties, I would say the parcels that are gonna be involved with the overall project, so that there's proper public notice that can go out. No issues with that, but when you get to the additional subsection 2 there, the specific areas to be occupied by the facility. The way I interpret that, or as I understand that, is the very specific area where the panels are gonna be, or sometimes we call it the fenced area, where all the equipment is gonna be. Because you can have times where you'll have, like, let's say an 80-acre parcel, and you'll have a 40-acre project on it. So it's not the entire parcel, it's that specific 40 acres that I think you're probably looking to identify. The problem with doing that at the application stage is these projects have to go through several layers of engineering and due diligence, and it's not until you submit for your final building permit that you really know where those are gonna be. And even then, sometimes it can change, because the engineer on behalf of the county could point out some things that might require some site design changes. So what we would ask is that you find a way to change the language for that second part to make it a building permit requirement, because we don't wanna go out there and do a survey, hire surveyors to go out there and do this really, really prospective survey before we've even gotten a permit approved, before engineers have had a chance to go through and look at the site designs from the county's perspective. But if you tied it with the building permit application, by that point in time, there's a more finalized site design. It would make more sense to have a survey at that point. So we would request that you make that consideration if you're gonna make some tweaks to this ordinance going forward. The next is going down to the bottom of that page, rolling over onto the next page, subparagraph 4. This asks us to identify locations and items that are within the project area and within 1,500 feet of that. And that's not typically much of an issue. The one thing that I would point out there is where it references subsurface drainage lines. There's a lot of work that can go into trying to identify old field tiles and subsurface drainage lines. And I'm not saying that that's not work that shouldn't be done, but again, doing it that far out in advance, before you really know where your project site is gonna be, it can be a bit of an onerous requirement, because you don't even know if your project's gonna get permitted at that point in time. Later on, you've got the requirements that you have to follow the AMA, that's in subparagraph 7 there, shortly below. The AMA requires that you repair any underground field tiles and drainage tiles and things like that. I believe it's within 14 days. So there's already some provisions there about dealing with that. You could also add into your building permit requirements that the subsurface drainage lines be identified at that point in time, because again, now there's a permit that's been granted, now we're moving forward with a potential building. Now it makes sense to go out there, because sometimes they have to go out there and just probe to find old field tiles, because the farmers will say, like on the farm where I grew up, my dad can say, I know there's a field tile that runs out there somewhere, but we put it in back in the 60s, we didn't map it, or earlier than the 60s. So you just gotta go out there and start probing. It's a lot of man hours. Sometimes they can use some GPS equipment to run them back up the lines. You find an outlet, you put this little device in, they start running them up the lines. But there's just a lot that can go into it. So if you're gonna ask us to identify all the subsurface drainage, we just ask that you have the developers do that at a later stage before the building permit. Then continuing on down, it would be the top of the next page. This is a pretty minor thing, but something for you to consider. The top of page 6, you're asking for 20 copies of the permit application to be filed. Sometimes these permit applications can run up to 100 pages, so that's a lot of copies. You're also getting an electronic copy, and nowadays you can make copies pretty quickly from electronic versions. So I would just, for the sake of your staff not having a whole bunch of paper sitting around and a whole bunch of paper having to be printed out, just consider maybe reducing that number down a little bit, and then require the applicant that if additional copies are needed, that they provide those. Because I've been in other counties where they've required a number of copies, these huge applications get printed, they get dropped off, and then the zoning officer, and I know you don't have a specific zoning officer, but whoever's gonna be doing that work, months down the road has a huge stack of applications just sitting on the desk that have never moved, and they don't know what to do with them, so. Jumping down then to page 7, sort of halfway down the page, subsection E there, where you're talking about noxious weeds, and this was something that Andy brought up.
What page was that?
I'm sorry,
Page 7.
yeah,
Page 7.
middle of page 7.
All right, got it.
Really just the last half of the last sentence there, no problem with having this weed management plan and dealing with noxious weeds, that's totally appropriate. We would just, instead of it saying shall be a cause for termination of the special use permit, just say that it can be grounds for a default, and then refer to your remedy section. So you've got a section later on that talks about dealing with these, and the county sends notice, and then the applicant has a cure period. So rather than just using termination language right there, we would just ask you to consider either referring that down to the later paragraph or saying shall be dealt with in the remedies section, and can be addressed there. Then jumping down to, this would be at the top of page 9. So at the bottom of page 8, you start talking about public road use, and then at the top of page 9, subsection D and the dog there. The first sentence of that is talking about what I would refer to as identifying the roads that you're potentially going to use. Ultimately, you're going to have a road use agreement. Those road use agreements are pretty complex and have a lot of information, deal with a lot of stuff. Here, I think what you're looking for is just, identify roughly or generally the roads that you would intend to use so that we have some idea going into this what roads we're looking at. And we don't have any problem with that, but where we have a little bit of an issue is where it talks about, it says shall be identified and approved in writing by the specific road district commissioner and the county engineer prior to the granting of the special use permit. So we would ask you to do one of two things, or maybe both. If you're gonna ask that it be approved in writing, then we'd ask you to shift that to the building permit phase. Because again, these design changes go on all the way up until that point. And so if it was at the time of the building permit, then you would already have a road use agreement in place at that point in time. You'd have a written approval that would already be contemplated. If you want to have something prior to the building permit and you want to have something as special use permit, what I would recommend is instead of it saying I identified and approved, maybe have it say identify and acknowledged in writing. That way you know that we've told your county engineer and we've told the township road commissioners what roads we're intending to use in the future. Those will later be negotiated in the road use agreement. But it just gives them a heads up before we even get to the special use permit phase that, hey, these are the roads that we're contemplating using. So again, either switch approved to acknowledged, because then they just have to acknowledge it in writing, or if you want to keep approved in there, move that to a building permit requirement, and then the road use agreement will take care of the whole thing. Then jumping down to the page 10, would be subsection L in relation to the noise levels. So again, one of the issues that we get into when it comes to this type of stuff is when you're doing these things at the special use phase, sometimes it ends up it's being modeling. You're predicting, projecting what things might be. Here you're talking about making sure you're in compliance with the Illinois Pollution Control Board standards, the IPCB regulations as it comes to sound. And typically with solar, you're not going to run into as many issues with sound. I mean, the projects are typically pretty quiet. You got some noise that can come from the inverters, from the fans, specifically on the inverters. You can run into the same situation with the battery storage units with fans that are running to cool those units. But a lot of times those only run, for the inverters during the daytime hours. Typically they're not very loud and they're generally centrally located on the project. So the sound typically doesn't become much of an issue with these. Nevertheless, it's still good for you to have the IPCB regulations there in place. But what we would ask is that demonstration of compliance with the noise requirements, again, that be moved to a building permit stage. This early on in the process, with supply chains being the way they are sometimes, we're not sure exactly what inverter types we might be using, and different inverters have different sound levels. Not sure exactly with the battery storage systems whether it'll be this model or that model. They might have a newer model by the time it comes around. But what we would be doing right at this point is really guessing as to what models we might use, and then using those guesses to create a model that projects what it might be. So it's sort of guesses upon guesses. If we push that back to the building permit phase, again, you've got more specifics as to where you're going with this stuff, and we would still have to comply. And if we weren't in compliance, you don't issue the building permit application until we get into compliance and the project stalls out. So the onus is still on us there to get it done, but just at a stage where it's a little more certainty in terms of the equipment being used and all that. Jumping down then, bear with me here, I'm trying to find my next highlighted spot, is on to page 14. So this is the defaults and remedies section that I was sort of making reference to before when we were talking about the lead management. That instead of saying, will be grounds for termination, just say it will be the grounds for a default, or that it can be a violation, which can be dealt with in the defaults and remedies section. Here, the change we're gonna request is that you've got a 30-day cure period. So any issues that come up are supposed to be cured within 30 days. You do have some language in there that allows that cure period to continue on if there's work being done on it. We were just asking for a longer initial cure period. So maybe instead of 30 days, going with 120 days, gives a little bit more time to get, the workers out there and get those things resolved. You still have subsection C, which is talking about if there's a real safety issue, like that it puts anybody's safety at issue, that has to be dealt with immediately. So that's addressed in C. But if we're talking about in subsection B, it's a weed issue or something like that, depending on when the complaint comes in, if it's late in the season, how do we cure that? If all the plants are killed off in the fall, and now we gotta wait through the winter. I don't know, we're just trying to think through some ways of trying to address that, and we thought at least having a longer cure period to start with would be one thing you might consider. So we would just ask you to consider that, and we suggest 120 days to start with. Then moving on to page 15. This was something that you brought up earlier when it related to the fees. On the building permit fees, our recollection was that there was some discussion about capping those fees. At least on the draft that I had, there was no cap that was listed for the building permit fee. So we think that a cap is appropriate. I think that.
Not to cut you off, but there is a cap of 100.
Is that a newer version? Right.
Yeah.
This was the version I think we took offline, so it didn't have
100,000.
Okay, all right, so if that's in there, that's all.
100,000.
Yeah.
Okay. Then at the bottom of that page on the hearing factors, so this was something that you brought up earlier. And I'm not gonna dispute anything that Andy said in relation to the LaSalle Sinclair factors. The one thing I would bring up, because I know you had some discussion about this the last time I was here, about how this could be implicated in litigation. And I think that you'll just have to, if you do intend to put those factors in, you'll have to be cautious and conscientious of how you may apply them. As Andy was stating, they're factors that are supposed to be weighed. It's not a single factor analysis. You have to try to balance those things. But I will say that recently there was some litigation that was filed in Grundy County. So Grundy County denied 2 community solar projects. There was litigation that was filed. It went all the way through the process, and we ended up getting a court decision a couple weeks ago where the circuit court, so that's the local court there in Grundy County, made a determination that once the elements of the ordinance have been met, so basically once you've got requirements in here for setbacks, et cetera, once those have been met, that it no longer becomes a discretionary decision for the county, it becomes more of a mandatory decision. And the court there issued an order of mandamus directing the county to issue the permits. Now, that's gonna go up on appeal, I've been told, I don't know if they filed it yet, they may have last week, but I think Grundy County's gonna appeal that, so we're gonna have to wait and see what the appellate court says. But the initial ruling out of the circuit court would lend itself to the interpretation that once you get into special use permit hearings and you've created these ordinances, that if they meet the certain requirements of that, it's no longer discretionary, and these are discretionary factors. So I think that it lends itself to the interpretation that the LaSalle Sinclair factors, at least under that court decision, likely shouldn't be considered in the county's determination on an SUP. But it's still not a fully settled question. Like I said, it's gonna go up on appeal. The appellate court could see it the other way, but I just wanted to provide that to you as a little bit of an update as to what's going on in our industry on the legal side. But aside from that, again, everything Andy said in terms of being a balancing test and that most counties having this in there, that's all absolutely true. The next section would be in 16, or excuse me, it would be the top of 17, I think, at least on my way it lays out on mine. This is the revocation section. And the first paragraph you have there is essentially indicating that if there's something that's happened with sort of government regulations that's held us up and prevented us from continuing to move forward, that we can get an extension on the timeline for the SUP to give us more time to complete the project, because, you know, we're dealing with either a governmental or utility issue that's slowing us down, something that's sort of beyond our control. We wanted to request that you add a second paragraph, and this one is longer, and so I've sent a copy to Andy for him to look at and to consider. But it's essentially, it's a force majeure type of section where it's saying, if there's any other issues, not just a government issue necessarily, but if there's a natural disaster issue or, you know, plague or something like that, hurricanes, wildfires, it lists all of those things, essentially acts of God that are beyond our control that would prevent us from completing the project, that you would give us an extension on the permit timeline to be able to try to keep the project moving forward. It's something that you find in a lot of contracts. I imagine a lot of the contracts the county enters into, especially with construction, there's typically a force majeure type of section in there. So the reason we were asking to add this is because your section makes it basically just governmental and regulatory permit issues. This second section would add in more of the typical force majeure, acts of God types of issues for you to also consider in granting an extension. So I won't go through what we're proposing on the full, because it's a big long paragraph, but we sent that over to Mr. Kite, and then that can be considered if it's something that you want to add in. I think you could say, you know, we want to add in a force majeure clause, and that can be added.
You're saying for us to consider, not saying that it's automatic, we would consider that.
Well, I'd ask you to consider the language. I think what we put in here is, I think we proposed in here language that said, if it is one of these things, like a force majeure type of thing, that the county board shall extend the permit period. Now, it says shall, so that would be mandatory,
Right.
but you could also make that discretionary and say, we'll consider.
Okay.
But we were just asking that you add some language in there that's
Right.
something beyond governmental permitting, that it could be other types of issues. So, I know that's a number of things that I covered, but that takes us to the end of the proposed draft that I had. So, again, we ask you to strongly consider implementing some of those changes. I think several of them are what I would consider to be sort of minor changes, and they make sense procedurally and logistically as to how these projects develop and when certain things become more clear, like the types of equipment, the types of inverters for sound, the survey area to be used. If you make those building permit requirements, I think it also provides better information for the county to use, or prevents us from having to recreate information. Because if we provide you with a survey at the SUP hearing, and then later on the project area shrinks, because sometimes that happens, these projects get smaller. We can't get any bigger. Once you give us a permit, that's it. You can't get bigger, you can't expand without coming back to you for a new permit. But it might shrink down, and if it shrinks down, then all those surveys are out the window. We've got to go resurvey all again, provide you all new surveys. So for some of those things, I think if you shift them to a building permit consideration, it would be probably procedurally and logistically maybe a little more effective.
Okay, anybody else? Comment? Okay. I think you're at the stage, do you want me to address any of those things? I can, otherwise you
I
could.
actually would like to say a few
Oh,
things.
okay.
I know that you're gonna probably say this is not possible, but the language talking about decreasing from 1.5 mile notification to half a mile, I would absolutely oppose that, because living out where I live, there is no one within 1/2 mile, so there could be just one family getting a letter. So I think it's very important that maybe that even be increased, so that there, you know, in Edgar County, there's a lot of desolate areas, so there might be 1 or 2 families getting a letter only, even within 1.5 miles, you know, and so regardless of the visual impact, there is an impact, and I think that people should be aware. The other thing is, this is a part that I think you might tell me you cannot do, but he's talking about you said the LaSalle St. Clair factors, and how there was basically litigation in Grundy County about it, saying that those do not come into play. So if those don't come into play, and it's basically a check the box on your ordinance, there's no recourse for the public once these contracts are signed. And the contracts are all signed prior to the application being brought forth to the county. So I think that there needs to be something brought forth in the county where the public can be notified before the contracts are signed. Because once the contracts are signed, these landowners are bound in contract and can be sued if they breach the contract or say they no longer want to be part of this. And the only way they could get out of it is if the county board voted it down. But if the county board has no way to vote it down, then these companies can go around to the landowners and get them to sign up before there's any discussion from the community. And going to these Coles County wind meetings recently, one of the landowners who signed up her farm got up and said verbatim, "I've learned more about wind in these meetings than I've ever known." And so these people are signing up their farms often without knowing anything about what they're signing up for, any of the hazards, or any of the impact to the public. And additionally, I understand that it's property rights. We're talking about property rights here. People own the property and they can do what they want on their property. But essentially, they're not impacting their own property only. They're impacting their neighbor's property. I would liken it to inflation. The government comes in and prints money and they say, well, we're not taking money from you. We're just printing money. But they're actually taking money out of your pocket by way of inflation. It's a secondary form of stealing from you. Similarly, when you put a solar farm on a property or a wind farm on a property, you may not be outright doing something to your neighbor's property, but secondarily you're doing it by way of putting something on your property that ultimately impacts their property value without them being able to know you even signed a contract until it comes forth to the county, in which case you can't have, you have no recourse because the county is now checking boxes that are on an ordinance because we can't even talk about potentially talk about the hearing factors that are provided within that. Or make something else within the hearing factors, make something else within the ordinance that provides these hearing factors so that the public has some recourse and ability to have a conversation on whether or not this comes next to them. The other thing I would say is increasing application fee, because the application fee, in my opinion, is very low. I understand it's just to provide for attorneys and things, but as Mr. Kite was saying, somebody could be out there to see like whether the weed management is okay or whether anything's going on with the project. Who's gonna do that? Who on the county board is gonna go out and observe the project every day to make sure that everything's going the way it's supposed to go, without being paid extra? And if it goes to hearing, these meetings can go on for days and days and days, and you have public being drugged through hearings. And with the way things currently are, there's legislation at the state to decrease the tax levies for solar. So the money that the county will be getting from the solar panels if they come in is going to be lower. Mary Miller, our United States representative, was just talking to Trump the other day. She texted me in a conversation with him that basically he said, get out the subsidies. Solar and wind right now produce about 20% of our energy domestically, but they get 50% of the taxpayer subsidies. If these subsidies go away, where does it leave these solar companies? And so the only money the county might see might be from the beginning with this application fee. And then you're left with these projects that who knows where they're gonna be in 10, 20 years. So anyway, that's all I have.
I'd be more concerned not about the application fee, but the permit fee.
The building permit?
That's the one that
I think that's what she was referencing.
Or either one, either one.
Okay, because we have to refund the first one unspent, but
Yeah.
that second one, if we have something that we're 8 years in the project and there's something that blows up, what do we use?
So two things on that point. So if you, on page 14, it talks about the special use permit application fee. It has a max cap of $250.
Right.
If they exceed that, they still have to reimburse the county for those costs.
I understand that.
So I think you're good on that one. I think what Rita was talking about was the building permit fee, I think. Or is it either one?
Either one.
Yeah, I get it. The only
But yeah.
problem is we have on the special use application fee is our fee it has to be reasonable, so if you know, the only way to really make that work is either you don't have a cap and you just make it refundable, you could do that. It currently has a cap of 250, but it's unusual to go above 250, particularly on a solar farm. On a wind farm, you might get above that. That could happen on hearing a project. A solar farm, I don't think I've had one that's been anywhere close to 250, even on a utility scale one, but there's some argument to that. The building permit fee, it's up to you. If you want to have a cap, have a cap. If you don't want to have a cap, take the cap off. It's up to you. The only thing I'll tell you though is, in addition, there is a paragraph that if you have costs, outside costs, in paragraph C, any costs that the county would incur, the developer would have to reimburse the county for. So if you have a cost in relation to, hey, we have to go out and do some enforcement, you can recoup that cost. Now, it's not, you know, it's easier to have it upfront and then go chase somebody down for it, but at least so far, we've not had any issues with a developer reimbursing the county for the costs that they've incurred so far. I'm not gonna say it isn't gonna happen, but it hasn't happened yet. I'm happy to address anything you want me to address from what public comment has been, but it's up to you. I mean, I can quickly go through it if you want, but.
Is there any other public comment?
No, he already has.
Yeah.
Wyatt?
So my question is, I know I sent over what kind of suggestions we had from a Farm Bureau on the county level and state level perspective. So I know Lisa, we had talked and said we were gonna talk with the attorney, and we just hadn't had a time to connect between Friday and now, obviously this morning. So I guess my question is, what did those conversations lead to? And the main 3 points, at least on the solar side, I know BESS is a different beast right now. So like the farmland drainage, 0.8, one we talked about, and so forth and so on. Could you give me some more detail on what you guys decided to do on that?
Well, hold on. So in terms of our discussions, our brother's discussion.
Right.
But in terms of, if you're asking about a specific point as to issues that you're raising, if you go through it, I'm happy to address them. If you're talking about drainage is already handled within the code. So under the statutory provision, they have to comply with any statutory provision that's listed anyway. So we could list it in the code, or in the ordinance, I mean. You could list it in the ordinance, but even if it's not listed, they still have to comply with that provision. So I think that was one of the issues that you had brought up.
Yes.
Yeah, okay.
Yeah, it was the farmland drainage plan, having a plan for it. It would have been like 0.8 underneath 0.7 of the AMA.
That part's already in the
Yeah.
AMA.
Yeah. And then we had a suggestion when it came to a pollution insurance policy. Wanted to know where you guys ended up on that.
So you would have an insurance policy, so you have a certificate of insurance requirement, or an insurance requirement. If you are looking at the ordinance, the insurance,
7.8.
the insurance provision is listed,
So bottom of page 13.
there you go, I was getting it. So their liability insurance, regardless of the project, they would have to have at least $5 million in insurance and $20 million in the aggregate. Which essentially means a per occurrence claim is, if I injure everybody in the room, one claimant who has a claim against me is an occurrence. The total is in the aggregate. So you would have $5 million in insurance per occurrence and $20 million in the aggregate. So before they can get a building permit, they have to come and provide proof of that insurance. Occasionally, what sometimes happens is we kind of talked a little bit before, when a specific project comes in, any project like this, we would recommend attaching conditions to it. We sometimes, in some counties, want to have a specific provision of policy insurance that relates to pollution. So, or it might be something, mine subsidence or something specific. And so we can always add a condition of approval to be that you have insurance covering a specific issue. So you can always add that as a condition. I wouldn't necessarily put it in the ordinance because the ordinance has a broad base of what the insurance is supposed to be. We want a general liability policy. More often than not, their general liability policy always will have a pollution coverage within it, but we can always add that as a condition of approval. So when a specific project comes, if you go, hey, this has battery storage as a part of it, we want specific insurance requirements as related to that battery storage to include environmental protection or pollution or something along those lines. Okay, next.
Yeah, and then point, or it'd be 8, and then adding with point C, how estimating the cost of decommissioning the solar facility on the 10th anniversary. I was just wanted to know where you ended up on that.
So under the statute, we talked a little bit about that, but under the statute essentially states that we are confined to what the AMA says in terms of decommissioning, how that's done. We oftentimes give concessions where we may revisit decommissioning more often. It might be every 5 years. It might be if it's not every 5 years, we have an inflation escalator to every year of that decommissioning financial assurance, for example. Might go up 3% every year. Might go up 4% every year. So we can't put in a specific provision that would be in conflict with the AMA, but we typically, in negotiating that, we would have better success dealing with it on that end than we would putting in a specific provision that might conflict with what the statutory requirement might be.
Okay. The only last thing, just for clarity, are you intending to have a BES ordinance hearing separate from this?
That would be separate, yeah.
Okay.
This is only a
Just so I can take that back to my
Yeah.
board of directors.
Good.
Best and revised wind.
Yes.
Yeah. Okay, any other question? Comment? Seeing,
No, I didn't know if I got a chance to respond or not, so.
no.
Okay.
Sorry, I think we're running long on time is what our issue is.
The only concern we have, as a board, we understood from one of the companies that time was of the essence, not that we're gonna be rushing any decision based upon that. But given all of the issues that have been brought up here today, I don't see us voting on that on Wednesday,
I agree.
which is gonna
I
be.
mean, all these,
Yeah.
concerns they
Yeah,
brought up.
I mean, you're kind of stretching the time out, and we were going to, we figured that this was, we'd only heard about one issue, and now we've got multitudes of issues. And I don't see how we make a decision on this until we have all the, we've had a chance to.
Next meeting or
Yeah. I mean,
Or a special
thereafter.
meeting if we get it
Yeah.
rectified. It's up to you. I mean, I could probably provide response on some of those and suggestions if you want. And you may want to
It's up
have
to the
time
board.
to think about it.
Should be more specific on decommission, I think.
Well, decommissioning, go
I
ahead.
mean,
The
maybe it should
one,
be more specific on what we're actually gonna do when the time is up.
yeah, what I would
That's
generally
part of the
suggest on,
permit. Pardon?
yeah, I'm sorry, I don't mean to interrupt you.
No, that's part of the permitting thing.
What I would,
When we answer those questions.
yeah, what I would suggest
I
on,
think Dan needs a copy of the AMA.
Yeah.
yeah, we could get you a
I
copy of
think
that.
that's what Dan
Yeah.
needs.
Copy of what?
The AMA, the Agriculture Mitigation
Okay.
Agreement,
Yeah,
that the state has, that
Okay.
they have to follow. Then I think that'll
Okay.
answer a lot of your
It's
questions.
a 12-page,
Yeah.
I looked at it on the website.
I got time to read it.
You got
That's spare time.
between flowers and cats?
Flowers, cats and all
Okay,
that.
I'm sorry.
no, you're okay. What I would suggest is, I think what you're suggesting is, you've gotten a lot of new comment
Right.
from various people. What I would suggest then is, if you're like, hey, we don't want to feel rushed, and
Right.
I think what I would suggest at that juncture then is say, hey, why don't we just take those comment, and then you guys consider it at a study session or whenever you would want to do that, and just let me know if there's questions. I could probably provide you like a one-page sheet of, here was the comment, here's what I would suggest kind
I
of
think
thing.
that should be,
Yes.
that
Yeah.
should be done as soon as possible.
Yeah, we can do Yeah,
Okay, and then we, depending on when we get it, can get together and discuss those issues. Carl, thoughts?
You mean, and then at some point, come back and make some changes to this?
Possibly,
currently?
yes.
And maybe go ahead with what we've got? You're saying just table everything
Yeah,
till
At
we
this point,
consider everything?
yes.
Yeah.
would you,
I mean, that's, another option is to pass it and then, but then if we amend it again, then we
you gotta go through this process
we
again.
Okay.
gotta go
Got
through
it.
this process,
Got
and we
it.
don't wanna do that.
I
When's
understand.
your next county board meeting's on Wednesday?
Correct, and we have that on the agenda
Okay.
to pass this.
I-
But I don't see how, yeah, we'd have to table it at this point, because we've got, I forget how many changes you've got in the.
I don't know how this affects what's going on with you.
Yeah, because we were given to understand that we needed to pass this in June in order to make some of the requirements for your supplier.
So we, do you want to?
Yeah, yeah.
These were suggested changes, right? So, and as maybe I should have made more clear at the outset. The ordinance as you have it drafted could go through and we can move forward with our project. We were suggesting a few, what we consider to be minor tweaks, you know, changing something from building permit to, or from special use permit to building permit. We threw a few things in there for consideration, but really, we've been trying to work with the county to have you get in place a new ordinance before we file an application. But we do have some timelines that we're working on. You have to work on your own timelines. But we were hoping to try to file under your new ordinance as opposed to your old ordinance. So if it's a matter of passing what you have now and coming back and making some tweaks later, or considering some tweaks between now and Wednesday, because you don't have to have a consensus today, you can vote on it and make changes on Wednesday if I'm understanding correctly, and Andy will correct me if I'm not. But come Wednesday at your meeting, if you say we've thought about it between Monday and Wednesday and we think these couple of changes are good, we're gonna make them. Or if we think, no, we don't wanna make any of those changes, we're gonna leave it as is, you do that too. But I'm not gonna tell you how to run your timeline, but yes, we do have some internal considerations as to when we file our application.
I could give you probably by this afternoon, a one-page sheet that basically says, here's what was commented on, and here's what our suggestion would be. And then you guys could take it up at your meeting if you wanted to. And then if you get to Wednesday and you say, well, you still want to think about it, you can table it then. I wouldn't necessarily take it off your agenda yet. I'd probably just.
We
leave it on.
can't, I just,
You know, I guess my impression is always it takes you guys a long time to decide.
It does. It does.
because the last time, yeah, it was
Yeah.
So, but if you
longer
think
than
you
I
can do
thought
it
it was
quicker,
gonna be.
then that's.
I could get it to you this afternoon because I've got time between now and I have to be in Charleston at 6 p.m. So between now and 6 p.m. I have time to send you something. It would just be an email, but you know, I think you could probably take that and I can send it to Lisa and you can take it from there.
So if you come
Send
in
it to Augie.
a week from now with an application and we don't have this passed, then it goes back to the old ordinance?
Oh, I thought didn't we suspend that?
We put a moratorium
We couldn't, okay,
So yes, it would go back to the old ordinance.
which you don't wanna do.
Well, I don't know that your old ordinance is in compliance with the law. And so there would be some question as to whether your old ordinance would apply or whether just the state law would apply. That's why we've been trying to obviously work with you and hold off on an application until your new ordinance is in place, which that's still our intention. That's what we want to try to do. I wasn't trying to make it more complicated here by throwing a few things out. I know it seemed like a lot what I went through. I think maybe once it's broken down on paper, it will be
Yeah.
Right.
less
It
imposing.
And what you said made sense.
Yes.
You start
Most of it.
shifting stuff and, you know,
But
it just,
it seemed like a lot, but I think a lot of it was just, it's the same information. It's just at a different stage in the applications, the majority of what you were asking for.
so you're gonna get it to us,
Yeah, if you can get us that.
So,
Yeah, I'll get it to you this afternoon.
and then we can discuss, make sure that it gets out to everybody.
Yeah. I mean, it's not far from here to Charleston, so I'm gonna have time to sit and send you something. I don't think it'll take too long.
Okay. That makes sense.
Okay. Well, with that,
We'll close the public hearing.
okay, there you go.
We're gonna take a quick break and then, and they're all,
Good job, that's not like you.
that's a world record.
We can make it back practice if you want.
The only time he
I'll
did
go
this
and help you
was
out.
when he didn't show up.
I'll get you a picture of that bridge right now. I must hand him a picture if you guys in the middle of something.
That's
I
fine.
won't say a word.
We'll wait a second, Kim, till Lisa gets back.
Information this morning.
Morning.
Just want you to know the board really appreciates your legal advice on that one.
What was it?
Phil stepped out to get pizza. It's gluten and carb free.
And then I'll drop the package off this afternoon.
That's Phil's new pizza joint.
You hear me?
I don't think it would taste very.
Okay, this afternoon, I'll drop your Wednesday package off.
Just cardboard. Oh, Carl, you just want to look at it real quick?
Do what?
Are you leaving or something?
Real quick.
No, they're talking too much, I can't hear.
We're starting up right this
Okay.
minute. Okay, Kim,
Good morning.
good morning.
I'll just dive right in? Okay.
Yes, please.
I think the only thing I came to talk about today was we're currently, and I think you guys are familiar with this, I went ahead and had Janet point out what we're looking at, but it's the GATA portal, and it's just out of compliance right now. And I'm just concerned because we had last Friday, I was at an administrators meeting, and Kankakee had just lost $300,000 in that because their GATA portal was out of compliance with the parent county. So it affects every entity underneath of it. But we're in limbo right now to where we have several, this one over $100,000. It took me about a month to write that grant too, so I just don't want that to be in limbo because they've already opened it up to the counties who were out of compliance. They were really on top of it this year for some reason. And those counties out of compliance had to reapply. So we're not in that second pool either, so we would be, I don't know what would happen to us. So I did bring and we talked.
He's the one that we rely on as a
That's
total candidate.
Joshua,
Yeah.
we chatted this morning, so I think we're all on one page and we're just looking to, and Joshua, I printed off what we can see, if that's helpful at all, I'm not sure, but.
What's GATA?
It's the Grant Authority, Grant Accountability and Transparency Act, and for maybe the last 8 years or so, it's where you have to have every county entity has to have all of their audits and everything, and their W-9s, basically everything to say, yes, we are able to accept federal grants and we can do this, or even state grants because it is an Illinois GATA portal. But our Health and Human Services grants that trickle down through the Illinois Department of Human Services, they're the ones checking that portal to make sure, and they won't release any funding or they will not accept your grant if any entity with your parent organization or within your county is out of, and this one in particular is the consolidated, it's something, it specifically says what needs to be uploaded in that.
For
Page
example,
2.
if she's trying to get a grant and the highway department isn't up to date on GATA, she doesn't get her grant money until they are, and vice versa. Everything has to be filed, sealed, delivered, correct, corresponding numbers.
It's funding, any funding that goes through the state. If the federal funding doesn't go through the state, then GATA doesn't matter. It's only funding that trickles through them first,
So is everybody in compliance?
so far. Well,
Well, that's what we got a letter saying we're out of compliance, so, and I just didn't wanna wait until the deadline on the email was June 24th, but I
I'm just here to say,
So
can
you're
we get that
working to get
faster
it.
in the
It's
agenda?
this cipher thing that we have an issue with every year, that the auditors has to go through and make sure that this breakdown's
So
correctly.
someone's working on
Auditors
getting it.
has to review it, and then they have to give us a letter, and then we go through this every year.
Yeah, we
We
do.
look at it.
It should be better this year because of everything sooner, but we'll see.
Yeah, they were just really on top of it this year, and that's what we heard too, was it was the first time they had checked by the May 30th deadline.
Usually it's something that we
Yeah.
do in August or September, I
Right.
think, so.
And it just so happens that our fiscal year with the state is, ends at June 30, so all the grants are all submitted or getting ready to be submitted before that date.
Thanks, Josh.
Yeah,
I
the
just-
requirement, the deadline depends on the type of audit we do. The type of audit we did this year was due in May. If there's a different one that's due in August, I don't know what the difference is, but it's the type of audit that sets the deadlines, so.
Okay, thank you, and let me know if there's anything
No,
else.
I guess I checked with him too.
Okay.
So that's what he needed.
Thanks.
All right, thank you.
That's it? Jacob?
Hi.
Hi. He's got nothing but good stuff for us today.
That's me, I'm just a good guy. So, I got stats and stuff for last month, but I can wait to show you guys those on Wednesday if you want, or I mean, I can give you guys some now if you want to look at them, in case there's anything you want to ask me about on Wednesday.
I think you need to hit the big one.
Okay, so I reached out to some of our local villages and the Neighborhood Watch about trying to get more flock cameras. I think they've been doing a good job for us. Right now, you guys know we've got 5 floating around, and then we've got a flex camera. I'm proposing to try to get 3 or 4 more of them. The Neighborhood Watch has told me that they would be willing to fund up to $500 per camera for up to 3 cameras to assist with it if that was something you guys wanted to do. I've also been in contact with Brockton, and I've got to go to a town meeting Wednesday night to discuss possibly them funding or giving us some money for one to put one in theirs. The mayor of Vermillion has said that they're willing to try to fully fund one, but if not, that they're definitely interested in giving us money to help put one out that way. Still haven't gotten in touch with Bill McCord, the mayor of Metcalf, but Troy Eads is working on that to see about getting one put in Metcalf. And I'd really like to put another one out on Clinton Road, closer to the state line. And so that's something that I have worked on. Now this morning, I didn't have a whole lot of time, but I was able to go in and you look in Flock, and it tells you how many hits, how many reads, or I guess how many vehicles passed by a camera for the month. And in Edgar County, just our 5 cameras that we've got active, we've had 149,694 camera reads, which is, is a lot. So I can actually break it down by camera, and I started to do that this morning, but then when I tried to print it off, it didn't look right, so I just printed this and came in here. But I can do any of that stuff, which actually kind of can help you guys in more ways than just law enforcement, as it's reading how many vehicles are passing a certain area, almost how like your road surveys do. And those are numbers that I could actually provide. There's nothing wrong with that because it's not giving any license plate data or anything, just numbers. So, yep, so that's the biggest thing on my list is trying to get that, and I can put together, if you guys need, examples of cases that we've solved using them, but they've definitely helped. They helped us with this last murder case. Just the other day, they helped us find a missing person, an elderly guy, so, they're doing good things for us. So
What's the current cost of a camera and what's the maintenance fee every year?
they're $3,000 a year for 2-year contract, so there is no maintenance fee for us. Anything that happens, they're supposed to fix. And so we have not had any issues with them breaking thus far. So
And what's the upfront cost?
there is no upfront cost because they're going to waive any installation fees this time because we're existing customers. So it would just be $3,000 per year for a 2-year contract.
Are you looking at fixed, are you wanting fixed cameras or more portable?
Fixed. I don't like the portable one. I'm working really hard to get our portable one even active because in 3 years we've had it, we haven't turned it on. So I turned it on last week and it doesn't work. And so I've been dealing with Flock to get it working. Once I get it working, I plan on buying, I'm just gonna make it a fixed camera. I'm going to buy a solar panel, probably at Rural King, that will work. You can plug it in. And I was gonna see about maybe out here at the new jail and talk to you guys about it, see if I couldn't get them to sink a pole for us. And I will just put it up on that pole facing whatever direction we decide is more important. So, and that's my plan to do it. I've also discussed with Flock that when the contract for that thing goes up, that they might take it back and replace it with a fixed camera.
You can't get
Because
them to-
they're $500 cheaper for a fixed camera.
You can't get them to do it before then, like,
No, I've already
it's
asked.
not working?
Yeah, well, right. I've already asked about that. They told me no. So, but my plan is to try to get them to take it back after the contract and possibly replace it with a fixed camera. So,
Currently, we have $12,500 budgeted for Flock, which covers our existing cameras. So we'd have to take a look at how that impacted the budget.
sure. Well, you know, and I'm not done working on trying to get financing for it because, like I say, I'm not trying to just throw this up and say you guys pay for it. As much as I would like to say put 70 of them, I'm going to try my best to assist with any funding before you guys make any decisions on yes or no. So,
Any other questions? Augie, do you have anything for me tonight?
I don't.
Mr. State's Attorney, you're not here, but I thought maybe you might have a word of wisdom or anything.
I don't.
Andy?
I talked to Ray, and he said he'd be willing to tear out the box in the downstairs courtroom. He and I talked about it earlier, and I said coordinate with Judge Isaac. I said, and as far as rescheduling what they have in that room and make sure that he gives you an open window to do that, and he will. So he said, yeah, I'll take it out.
He didn't think it'd be.
He didn't think it'd be a big deal. I said, be careful with the carpet when you do it, because we may need to put that up, maybe glue it along the front where the judge's podium is. And he said, yeah. So he's gonna do that. I did have, I was walking out, Jeff Wood stopped me and said he's had some people complain about the bathroom downstairs. So I talked to Ray about it. And he said he didn't want to do anything yet because Scott Blair is doing some repair work on the upstairs bathrooms. He wants to get them all done before, otherwise if he did that one, there wouldn't be a men's bathroom. So he wants to make sure and get that one all done, and then he'll get back with me on, he and Scott may do that one.
Keep what?
The downstairs bathroom, men's.
What are they gonna do to it?
Needs a new, you been in lately?
Oh, yeah.
Yeah, go clean it up.
Oh.
Maybe, do you have to have a urinal in that bathroom?
Yeah,
I don't know.
yeah.
We
Well,
could make it unisex.
Kim, do
Well,
you
that's
have
what
to have a urinal?
Usually that's the plumbing inspector and the plumbing code, usually if it was installed with one. But urinals can be sometimes interchanged with toilets. It's
is that something?
we could just put a drain right in the middle of the floor.
That's the problem, there isn't, that's what it is, there's a drain on the floor.
Is that a plumbing inspector question?
Yeah.
I mean, it's a guy's
And I think you
bathroom.
guys use
It's
the
promised not
state
to stare.
plumber, I mean.
Oh,
And I wouldn't have thought of it.
So I don't, yeah.
There are two toilets
I
in
don't know if you wanna
that.
go that direction.
No, we-
Because it's so, and if it's old, you might, yeah.
You don't wanna. well, we
The
don't
heights
wanna
have
go to the
changed
state.
in the last 10 years too, and sometimes they'll be like, oh, and your toilet, now you need to rip these up, where they need to be 2 inches higher, and it's like, really.
Well, I never thought about taking it out and putting one that hangs on the wall too, versus that one on the floor.
It'd be a moving one.
A moving one?
Yeah, because-
I've seen too many draws that
Andy, I have a
Those
question
are
about the,
usually out on the wall.
Yeah.
Sell it.
I have a question about the courthouse. You guys were talking about pulling out the jury box, correct?
Uh-huh.
I mean, obviously you guys do whatever you want to do, but I was thinking possibly a cheaper suggestion and maybe even a more secure suggestion would be just to pull out those juror chairs and replace them with benches. And the reason for that is I believe that you could put all the inmates that come from the jail, sitting them over there, and it keeps a wall between them and the judge.
You mean leave the wall?
Leave the wall and just put benches.
Well, we talked about opening up a small room there to put them in.
See, now if you do something like that, that would even be better.
Okay.
But if you
They're
guys are
not in
not,
the room.
but if you guys are not doing that,
Oh, no,
then I was just suggesting it would probably save you guys some money and it would actually create some form level of security by putting them over there, and it would create more seats for them. Because I believe benches, we could, you know, put a bunch more people together than say that you have 12, 14 chairs over there or something like that.
We're looking at actually the room that used to be the public defender's room.
Yeah.
Having that to where you could keep them in there, and as you needed them, you can bring them in one at a time.
That's a perfect suggestion.
Okay.
I mean, I love the idea, absolutely love the idea. Just, I mean, is there going to be, are we expecting the sheriff's office to have a security officer in there to watch them? Or are we going to put a camera in there to watch them and
You'll
somebody?
have to have somebody in there with them, I think, wouldn't you?
I also
Was
believe that.
Jeff there?
Jeff was there with
Yeah.
us.
So you might talk to Jeff what
See
his
what-
idea
yeah.
is.
You said Jeff Wood?
Yeah.
Yes, sir, I will.
Okay.
Okay.
Um,
Andy, what about the electrical?
I saw flags up the other day. Augie, have you seen anything, any movement yet?
Just the flags.
Okay, well, the flags indicated to me that somebody's doing something up there, but I haven't seen anything yet.
And?
I stopped last week's shelter, still got 40 dogs. There were 2 families actually adopting a dog that day, so at least got rid of 2 dogs. I think she's only put down 1 animal all year, which is really great. And then something about American Legion's gonna sponsor a adoption day out there too for us.
Excellent.
Which worked out
Excellent.
very well. So, other than that, did a good job.
Russ? Nope. Carl?
Nope.
Lisa?
We talked about the GATA issue. Still need to know what happens to old highway department signs when they die. And I am still planning on going to the UCCI state meeting in Galena on July 27th through the 29th.
That's dedication.
Isn't it though? Don't you admire me? Yeah.
Galena's a nice town.
Yeah, it
Isn't it
is.
though?
It is.
That's all I have.
We did have the closing, the money is deposited into our coffers. Don did well with his surgery and he's doing well, so just want to let everybody know. I'm sure any communication with him, he would appreciate, so.
Oh, I'm sorry, one more thing, kind of related to that. Nancy and I are gonna do another PAYCOM meeting, next week.
You having a problem with it or what?
No, it's all
Okay.
training, making sure we're using it efficiently and effectively.
You have the agenda in there. I don't think there should be any questions on anything, but if there is, let me know. Do you have anything else to come before the meeting this morning?
Who's Stephen Schneider?
He taught math, Crestwood. Good guy, good guy.
No, that's
He
his
actually-
dad.
Pardon?
Steven's his son. John,
Okay.
John taught math out at Crestwood
Okay.
for years.
This gentleman saw the article in the newspaper about the vacancy, and we were having trouble filling it. He called up us, and so we checked everything out, and so he's gonna be joining us on the board.
Great.
Board review, so. Hearing nothing further, I'd entertain a motion. Yes.
I just want to ask before, I had some questions about maybe some sheriff's office personnel stuff, and we could ask, I could talk to you guys about that another time, or if you guys, we could do it here.
later.
Okay.
Okay. We could do a closed session on Monday, or Wednesday, or
Yeah.
we could have
A
a.
closed session.
No, I mean, it doesn't matter to me, it's just,
Probably should be if it's personnel.
Well, is it,
yeah, okay, yes,
Yeah.
yes.
Yeah.
do we need to have a committee meeting, or just, well,
You're asking me things that I don't know the answer to, I'm
Actually, we'll
sorry.
just go and when we're done, go
Go into
into
closed session.
closed session, see what he's got, and then
today or Wednesday?
Wednesday.
Wednesday.
Wednesday's fine.
Yeah,
Okay, thank you.
all right. Motion to adjourn. Russ moves, Andy seconds. All those in favor signify by saying aye.
Aye.
Opposed, nay. We are adjourned.
Well, I'll drop your package off this afternoon. Okay.